Welcome to this explainer. Okay, let's jump right in. Today, we're tackling a foundational legal concept for anyone who's relocated to Spain, cambio de residencia, or change of residence. If you're living in Spain right now, especially if you hold temporary protection due to exceptional circumstances like the war in Ukraine, understanding exactly how Spanish law views your move is absolutely vital. It dictates your rights, your taxes, and some massive financial exemptions. So we're going to unpack exactly what this means, and more importantly, how you prove it.
Here is our roadmap for today. 1. Defining change of residence. 2. Why this concept matters. 3. 2 routes to prove it. 4. Documentary evidence package. 5. The objective facts rule.
Section 1. Defining change of residence. Moving your center of vital interests.
Right, so we really have to clarify what this concept actually means in the eyes of the law, because it's so much more than just a single piece of paperwork. Traslado de residencia is the legal concept indicating that your center of vital interests has moved from one country to another. We are talking about your home, your family, your work, and your effective day-to-day presence. It's a super common misconception that simply registering your address at the local town hall, getting your empadronamiento, magically changes your legal residence. Honestly, if only Spanish bureaucracy were that simple. But it's not. The empadronamiento is literally just one piece of a much larger puzzle proving that your entire life has definitively shifted.
Section 2. Why this concept matters. The financial and legal stakes.
You might be wondering, why should I care about some abstract legal theory? Well, because it directly impacts your wallet and your daily life in Spain. Establishing this change of residence is the foundational condition for a whole bunch of things. First up, customs. Under EU Regulation 1186/2009, proving this change allows you to claim massive exemptions on VAT and import duties for your vehicle and household goods brought from outside the EU. Second, your tax status. It triggers your tax residency for income tax, or IRPF, which kicks in when you live there 183 days a year or have your center of interest there. Third, it exempts you from the Spanish registration tax for vehicles, the IEDMT, under Law 38/1992. And finally, your social rights. Conditional access to Social Security, public health, and education are deeply tied to your effective residence. This isn't just bureaucratic red tape. This is absolutely crucial for your fundamental legal standing.
Section 3. 2 routes to prove it. Standard versus emergency relocation.
Spanish authorities basically use 2 distinct legal paradigms to verify this shift in your vital interests, and it completely depends on how you arrived. Let's look at the standard route first. This one is built for planned, non-emergency migration, and it relies heavily on processes completed before you even set foot in Spain. You start with a Type D visa for residence, work, or studies issued by the Spanish consulate back in your home country. Once you enter Spain, you apply for your Foreigner Identity Card, or TIE, within a month. Then you get your Empadronamiento, your municipality registration, within 3 months. You also have the option of bringing a consular certificate of change of residence. It's a very clear, very linear, pre-approved path.
But what if you didn't plan your move? For emergency relocation under exceptional circumstances, like fleeing a war, you bypass the consulate entirely. You literally cannot plan this migration. So your legal basis for residence becomes your temporary protection or asylum resolution. You get a specific TIE card for temporary protection issued by the National Police or CREDD centers. You still need your empadronamiento, but crucially, you have to rely on proof of circumstances demonstrating the impossibility of return. We're talking war documents or proof that your family is displaced. The authorities fully recognize that the standard paper trail just isn't possible in this scenario.
Section 4. Documentary evidence package. Building your case for AETT.
So, regardless of how you arrived, standard or emergency, you have to present a rock-solid package of evidence to the AET, the Spanish Tax and Customs Authority. You are essentially building a timeline of your life. First, your identity and registry, your TI and an empadronamiento certificate that's less than 3 months old. Next, proof of your new Spanish roots, like a rental contract or a property deed. But here's where people get tripped up. You also need proof of your origin. Your passport showing past residence, old rental or work contracts from your home country, utility bills, or old tax certificates that predate your move. Finally, you have to prove exactly when you entered the EU. You can use ferry tickets, customs stamps, or consular records. You're drawing a clear, documented line from your past life straight to your current life in Spain.
Section 5. The objective facts rule. Facts over formal documents.
Okay, this is perhaps the most empowering part of this explainer. Here is a very common hurdle. Spanish bureaucracy will often take one look at the word temporary printed on a temporary protection tie card and try to argue that you haven't permanently changed your residence. It creates this frustrating conflict between what a formal document says and the real-world objective facts of your actual life.
And this is exactly where European law steps in to protect you. European courts prioritize the objective reality of your life way over formal document titles. According to the European Court of Justice, specifically in the Loulou-Dakis and Commission versus Greece cases, normal residence is determined by the sum of objective facts, not by the formal document. This ruling is an absolute game changer. It is the legal bedrock that allows temporary protection holders to access the customs traslado de residencia regime. So, even if your card formally says temporary, if the sum of your objective facts, like your rental contract, your kids enrolled in local schools, your utility bills, prove your vital interests are now in Spain, you have the right to claim your customs exemptions. You are empowered to claim your rights based on the reality of your life, not just a word printed on a card.
To wrap things up, just a quick reminder that this explainer is meant as informational guidance to help you grasp these complex legal concepts. It's not formal legal advice. Understanding cambio de residencia is a huge first step, for sure, but every single person's timeline and paperwork is unique. You absolutely must always verify your specific situation with the official Spanish tax authority, the AEAT, or a qualified advisor. So I want to leave you with this to think about. If you were to lay out all the paperwork for your own move to Spain on a table right now, do your objective facts clearly tell the story of your vital interests making the shift? Thanks so much for joining me for this explainer, and keep learning.
That was a quick overview. On our website you'll find step-by-step guides to many procedures, the padrón, the health card, the NIE, the tie, legalization, and more. The link is in the description. And if you get stuck, message our Telegram bot. We'll walk you through for free, step by step.